Welcome back, everybody. So we have with us Jag Lale with Area and Deborah Bunston.
Yes.
That's correct.
Yes.
And you guys have played a key role in educating people. And quickly introduce yourselves in terms of your role with Area and kind of how you guys came to be involved in the contracts and the place where we got to today.
Okay, my role at Area is Senior Industry Advisor, and JAG is Advisor Member Services. So one of our key member services is the production and provision of forms for the use of all of our members. So JAG's fairly new with Area. He kind of came on the tail end of the project, but we've been working on the project for over a year and a half before the final form came out. So it's been a long project.
And Jag, you have also a legal background.
Absolutely. I was a conveyancing lawyer in Calgary for 6 years, and I also was a realtor before I went to law school.
Oh, really? Okay.
Yeah.
There you go. So you've seen this both
Absolutely.
sides.
Yeah.
I've worked on both
Yeah.
sides of the ledger.
God.
you could
Yeah,
say.
that's why he was such a good candidate when we were looking.
No
yeah.
kidding. Yeah, great asset.
Yeah.
So kick us off here. Obviously, there was a major overhaul to the purchase contracts. Why the big changes? Why the necessity for it? And what was the process that you guys went through to create those?
Okay, I'll spend a couple of minutes talking about that. It's pretty intensive. So our forms process is an ongoing process. We continually get feedback from members, the legal community, consumers, and so on. And we document every single comment that we get.
Wow.
So over time, we catalog all these different comments and what areas that they're focused on. And this becomes sort of what our agenda becomes for our Forms and Practice Committee. For this particular project, the old form had been around for about 10 years. And different tweaks had been made over time when they were needed, but it hadn't had a real good look for that period of time. So we did have a list of things we were looking at. REACTS, for example, and two boards, CREB and Edmonton, both made formal requests to Area to reconsider the deposit clause and the broker's decision-making process within that clause. Members had given us feedback on things like what should the seller disclose, what about tenants, these types of things. So all those things have been cataloged over the time. Also, a lot of inconsistencies, in the supporting forms. These are your amendments, addendums, notices, and so on. Signatures weren't lining up in the right places, so that was part of the whole purchase contract project because those forms form a part of the whole package. Also in 2014, you'll recall that's when the representation agreements were changed, the buyer representation agreement and seller representation agreement. And they went with a more plain language style.
Yes.
So we had a few funny little things that weren't matching up. For example, the purchase contract referred to a commission where the seller representation agreement calls it a fee. So little things like that. So we gathered all these things together and we thought, this might be a fairly major overhaul.
Yeah.
To decide whether we wanted to go that step, we wanted to get more member feedback. So in December 2015, we did a provincial-wide member survey. We got over 900 responses to our stock 5 questions that we asked. And then we had an open-ended question, and we got 400 individual comments.
Wow.
So that's what we did on January. We spent the entire month going through those comments, seeing where there were similarities and talking about them. So now we had a whole list to take to our committee. And so I should talk for a minute about our committee. It's called the Forms and Practice Committee. It's made up of a number of different layers. First of all, Area staff contributes because we're the ones that bring the topic forward to the committee, prepare the background reports, do the research, and so on. The committee is made up of 2 levels. We have voting members. The voting members are all practicing realtors or brokers from every region of the province because our form is a provincial form.
Right.
We also have non-voting members. These people support the work of the voting members by offering consultation. They have a dedicated lawyer to the committee, so it's a legal counsel to the committee. There's practice advisors from CREB and Edmonton, so the people that take all the practice calls at those boards, so they've got lots of feedback. There are, REACT sits on the committee, and they bring their legal counsel to every single meeting.
Wow.
So there's quite a few layers to the committee. So the process sort of goes that area staff presents the reports for the committee's consideration. So it kind of works just like an offer presentation.
Right.
We present it to the committee. They can accept the recommendation, they can reject it outright, or they can send it back to us to do more work. So with this particular project, we had, I would say, about 10 different meetings to talk about the changes. Some were formal around a table, some were by conference call, and so on.
This wasn't just two people and a glass of wine?
I wish. Then I would have got my own way on everything.
I feel like some people out there felt like it was
Yeah.
two people and a glass of wine, and we're going to speak to shortly here. But
Yeah.
it's like, I love that you guys put so much time into this, and I think the changes are incredible.
Yeah, there's quite a process. So once the committee does decide and agrees, and only the voting members get to vote, once they agree, there's another level. We have 2 levels of governance. So that takes us to the Area Board of Directors. Of course, the Area Board of Directors is completely made up of practicing realtors and brokers as well. So our Forms and Practice Committee makes a recommendation to the Area Board of Directors. And they're the ones that make the final decision. This is really great. It's kind of like, well, maybe comparing it to the Senate is not a good idea, but it does give a second set of eyes, a fresh look, and sober second thought.
Right.
And they have the same deal going on with us as staff as the committee does, accept, reject, or send it back for more work. So that's the 2 layers of the process.
So obviously very many people looked over this. And the interesting thing too, and, you know, when you get a survey, and we do this at CIR too, you know, and I love your process and how much consideration you took to those comments, but a lot of this was based off of members filling in that survey and writing their feedback, and the time that you took to make sure that you went over that. When area sends out a survey, you know, that your opinions are going to matter. So I think that's really important. So please respond. But to the whole kind of 2 people with a glass of wine thing, obviously there's been a little bit of banter with the Calgary lawyer Lupesta, who's been saying you don't need to use the contracts. He's been pointing out some faults. What are your thoughts on that? Do they have to use the lawyers, and why the controversy?
Okay. Well, the controversy, I think, is pretty much a difference of opinion. We had a lot of legal consultation on this project from the staff point of view. Like, there are the 2 lawyers on the committee, but from the staff point of view, there was certain lawyers hired to look at specific things. For example, a well-known Calgary condominium lawyer looked at the condominium form. That's just one example. In a general review that was in the summer of 2015, Lindsay, you were one of the people that gave us feedback on the draft at that time. That was realtors and lawyers from across the province who weighed in on the draft at that time. So all in all, I think there was 18 different lawyers that had their fingers in the pie. So you know that there was arguments, right? You know that there was disagreement. You put 18 lawyers, you know.
You have an ocean of lawyers out there, and legal opinions is just but one fish in that ocean, right?
Yeah, for sure. So, you know, all that feedback does give us the confidence that our process has a lot of integrity.
Absolutely.
So, of course, you know, in the social media world, on a blog, people have the right to express their opinion, and Lou's got his opinion, and he's expressed it, and that's fine. Now, he has identified some areas that, you know, he thinks are problematic, and one of the things he posted on the weekend was that the old form was better than the new form because the old form contemplated that the rights of an existing tenant would be protected. The possession was subject to the rights of an existing tenant.
Right.
So we saw that as a problem, and our legal advice was that it was a problem, including the advice from the Legal Education Society of Alberta. Essentially, with the old form, if you did not have a tenant, that section should have been stroked out. UC offers.
Yep.
How often was that section stroked out?
Never. Never.
Exactly. So we feel, and when I say we, I don't mean the 2 people in the glass of wine.
Of course.
I mean the entire committee and the entire process. We feel that most contracts are a vacant possession. most buyers and sellers are individual people. It's not an investment property. That in most cases, it would be vacant. And when it's not, there's a tenancy schedule to use and to check off in the offer when that occurs. So there's one of the differences of opinion. He thinks there's more liability, that the tenant might not be recognized. We think in most cases the property is vacant, and certainly if there is a tenant, you have to deal with it.
Yeah.
So that's a difference of opinion. Now, whether realtors must use the form, AREA is a membership organization, so we don't have big hammers, and our mandate is not to discipline or enforce. We know who does that, that's RECA. But we talked about the process just a second ago. We talked about the legal input, all the input from our committee, who's on the committee, and we really feel that the form as it is may not be perfect, but that it's better and than the old form. We've corrected a lot of problems, and we definitely recommend its use. Now, we've also provided, shortly after our members got it, we provided the form to the whole legal community in Alberta through the Law Society and through the two Canadian Bar Associations, Edmonton and Calgary. So they've had the form for quite some time. We've basically heard nothing back from them about their concerns, but it's not going to stop. In November, we have set up already a meeting with the bar associations to get their feedback once the thing is in practice with their practicing lawyer members. So we're expecting feedback then, and that's great because that's what we want. We've gotten lots of feedback from members. A lot of it very positive, and some areas where they're confused or have concerns, and then we point to our education resources. REAX, I said they sat on the committee, so as Lou said, well, obviously REAX supports the form because they sit on the committee. Well, they do support the form. And if anyone is thinking constantly about realtor liability, it's REAX.
Right.
And their legal counsel was very helpful to us in doing some of the liability clauses in the contract. Now, the only other thing I'd like to mention is from the practical point of view, which you guys will work with all the time, and that's realtors. Now, we have different boards across the province. I understand that Calgary board, and correct me if I'm wrong, requires their members to use the most current version of the forms.
Okay. Exactly. They encourage that. So.
And also, individual brokers may have an office policy about what forms their agents are to use, and we would never recommend that a person goes against the guidance and policies of their brokerage. The other thing is the form is no longer available on web forms. The old forms are no longer available on web forms or Repree.
Or our CRR website, for that
or
matter.
Your CRR website. So from a practical point of view of filling it out electronically and using those systems to their full use, that's going to be an issue for people using the old form. And one last thing is, even if you choose not to use the new form, you still have to understand it because you're going to be receiving offers on that form. So you may have, you have a duty to explain the offer to your client. So if you don't understand it, you've got an issue there. So you have to fully understand both the old one and the new one to continue to practice if you're not using the new form. Our feedback is very few people are focused on using the old form. A lot of people like the new form and want to go forward with it.
Just a quick thing from CR's perspective, we strongly encourage you guys to be using the new form. And any feedback out there that's recommending realtors to use the old forms is negating and being ignorant to the fact that there was problems and exposure points in the old forms. That doesn't solve the problems that were in the old forms. Every time you put a deposit out there, it created huge problems, especially for your seller in terms of, or your buyer in terms of disputes and how that was handled with deposits and things like. Any comments on that is totally ignoring those issues. And any type of feedback out there should be around, well, hey, what is the best practice for the dates on dower? What is the best practice for the 9.2 and additional terms you can put in? So use the new forms and then seek advice as pertaining to those clauses and those terms.
If I can just take one more point, Kelly has a slide, and we're talking about liability. So there's two areas in the new contract that will help realtors avoid liability. In Section 3, which is general terms, there's a buyer and seller due diligence clauses there. So this gives the buyer and seller guidance as to the things they should do, like check the RPR, check the title, those types of things. But this clause that Kelly's put up is called confirmation of contract terms. This was written specifically with REAX lawyers. And basically, it's the most legalese clause in the form, but because we couldn't stop them from being lawyers. But it does basically say that this contract is the entire contract. Anything that's been discussed outside the contract, if it's not in here, it is not relied on. And this is the only clause in the entire agreement that has extra place for initials.
Yeah.
Good drafting advice is that you don't bold or highlight or have boxes or initials on one thing and not on another thing, because it tends to mean that thing is more important than the other things.
Right.
The entire contract's important. But this is where we did put extra initials. So this would be a whole process is to have the buyer and seller talk these clauses over with their clients and let them know the seriousness of this offer and what they should be looking for. So when the clients understand and clients are informed, your liability goes down.
Right.
Okay, let's talk for a second about best practices. Our managers need to give advice. Keeping in touch with with what area REAX are saying. What are some general best practices with the contracts that you guys have noticed?
Do you want to talk about the dower?
Yeah, absolutely.
Okay,
so one of
sure.
the things that the 2014 contract really didn't address was dower.
Right.
And what we really made is an endeavor to do is touch upon dower in the 2016 contract. Now the dower consent or the requirement is not anything new. The Dower Act or its forms have been around since the 1920s. And I can tell you the number of times that I saw it properly dealt with when I was a conveyancing lawyer was in the low or maybe even 0%.
Right.
And part of the reason was because of the way the 2014 contract was laid out. Now, I'm not going to sit here and give everybody all the nuances of the Dower Act.
No, fair enough.
But what the Dower Act does is it prevents a single owner who's married to dispose of their property without their spouse's consent.
Right.
And dower consent is required at the listing, purchase contract, and at the property transfer stage. Realtors are involved at the listing and the purchase contract stage, so dower does have to be dealt with them.
Right. Right.
The new clause will now inform the buyer when dower exists and when they can expect that dower release to be provided to them.
Right.
The old contract didn't allow that to happen. So
What kind of dates should we be putting in there? What kind of time?
Well, again, I mean, its best practice is going to be to determine it's going to be up to the individual realtor and deciding what is in their, I guess, what the situation looks like as far as that they're in. So if they have maybe a spouse and a husband that are living together, everything's amicable, you could probably put it in pretty close to when the contract should be signed.
Right.
Now, if there's a spouse maybe overseas,
Right.
That could be, it might take a little bit longer to get that dower disposition or the dower consent.
Right.
So that could take longer. So I mean, we do want agents to play it by ear. Now we don't want it to be the day before possession.
Right.
Because a lot of the reasons why we're getting liability or why the old contract was attracting liability around dower is because the buyer didn't realize that there was an issue with dower until either the day before or the day of possession.
Right.
So they've gone ahead, they've sold their old house, they've gone ahead, they've rented the moving truck, they've made all the arrangements in order to move into the new house, and now all of a sudden there's an issue with them moving into the new home. So
from your buyer's perspective, just really quickly, in the new agreement, the buyer has the opportunity to void at that point.
absolutely.
So you go up to September 30th possession, your seller is ready to go, September 29th comes up, that's when the dower consent was supposed to be provided. You miss the time, buyer voids.
Yeah.
So
Yeah.
problematic if
Absolutely.
you don't get your dates right. But you need to know because the seller needs to be able
Yeah.
to prove they can sell the property.
Absolutely. Absolutely.
Cool.
On voiding potential contracts. So talk a little bit deposits for a second.
Sure.
So if something like a deposit is received late and the seller chooses to accept it anyways,
Yeah.
could they come back and use that at a later date to void the contract?
Yes, they could. Now, if the deposit's late, the seller can void the contract at any time up until possession date. Now, the one way to deal with this that I would recommend is if the seller is accepting the late deposit, get an amendment to the contract. An amendment to the contract will save you. There are some other legal avenues that somebody could deal with if a seller cancels the contract really late in the process and the buyer has gone ahead and done their due diligence in buying the property. However, we want that to be more of a last resort. If you guys are if you have a seller who's accepting a late deposit, make an amendment to the contract.
Okay.
I love what Deborah said too, right? Like if it is not in the contract, it doesn't matter.
Absolutely.
Yeah,
So make sure
exactly.
that everyture that changes is in the contract.
Yeah,
Protect your
exactly.
client.
Protect yourself and
One
your
more
client.
quick thing when we talk about material latent defects, something that comes up is obviously permits.
Right.
Or lack thereof.
Yeah.
Can you speak to that with the considerations of new contracts?
Yes, absolutely. So first of all, I'm glad you used the term material latent defect because the contract isn't saying that a lack of a permit is a material latent defect. We looked at the RECA definition of material latent defect, and there's some problems in that from a contract drafting point of view when you're talking about an agreement between buyer and seller, because it uses words like may include,
Yes.
or potentially,
Yeah.
or expensive. And what's expensive?
Mhm.
You know, people shop at different shoe stores, don't they? You
Yes.
know?
Yeah.
So we didn't want to use the RECA definition because you can't use words like may in a contract.
Right.
Also, we looked at various court cases, and courts are not consistent on what a material latent defect is. So in the absence of a black and white typed list of all the things that are material latent defects, we thought, how do we deal with them? Actually, we kind of got the idea from one of our members. The member question was, you know, if a seller knows they didn't get a permit, why don't they just tell us?
Yeah.
Why don't they just disclose it?
Totally.
And so that's the way we kind of went about it. We went to the representations and warranty section and thought, this is information that the seller knows. And we're only asking them to disclose what they know. So if they're in a 50-year-old house and some renovation was done 25 years ago without a permit, they wouldn't know that. So they're not obligated to disclose that. But if last year they put on a new deck and they did it without a permit, or they developed the basement and did it without a
Right.
permit, that's something that they would know. So if the seller takes on the risk of doing that work and doing that development without a permit, then who should the risk belong to when the property is sold? The risk should carry, in our opinion, with the seller. The buyer has no knowledge of this. In some communities, they can't even go and search for permits. And remember, it's a provincial form. So here's something the buyer knows, or the seller knows. So why not just disclose it? That gives you an informed buyer. An informed buyer equals less liability for the agent.
Yeah.
So now the buyer's informed. They could look at the work and think, it's fine with me.
Yeah.
They could look at the work and think, oh, well, when we get our inspection done, we'll get a little bit more inspection done on this
Totally.
area. Or they might, you know, walk away knowing that they don't want to maybe inherit a problem that existed. And that would be unfortunate. But also unfortunate is a buyer that buys a property and finds out there's a problem. One call we got was a young woman, bought a property in an area that was zoned for secondary suite, perfectly legal, and there was basement development already, which she thought was great because that would give her less work to do.
Yeah.
When she went and applied for the permits for the work she needed to do to upgrade it to be a suite, that's when she found out the previous work had no permit. And it cost her over $10,000, and stress and work and time and
Absolutely, yeah.
delay.
Yeah.
So that's a risk the seller took. I'm going to develop without permits.
Yep.
That buyer then inherited that risk.
Yes.
So that's kind of what the disclosure requirement is. It's not saying it's a material latent defect. The work may be perfectly fine.
Right.
But that's how it's been translated in the social media, that, oh, they shouldn't have to disclose that because it's not necessarily a material latent defect. A contract can require other disclosures.
Right.
Material latent defect is disclosure required by the Real Estate Act and common law, but a contract can require people to do whatever you want them to do as long as it's lawful.
Absolutely.
Yeah.
Absolutely. You know, I have to give a big shout out to Area here for obviously coming up with this, helping us out, simplifying the forms and stuff as well. You guys have put out a bunch of resources and
Yes,
tools. You guys
yeah.
continue to do so. And go to Area Hub, take a look at the practice resources for the
Yes.
contracts.
If you go to Area Forms, 2016 practice resources, there's a whole list of things, explanatory forms,
Yes.
backgrounders.
And we've
lots of
brought
stuff.
those up
Good,
before as
good,
well. So
great.
we've made the link available in our professional development section as well.
Ah, excellent, thank you.
One more thing before we finish, really quick here. So we're going to go over a little bit of time here, but you guys have a new program called Area Wireless. Now, this is quite the transition from contracts,
Yeah.
but you guys are always adding more value. So if we switch gears in your head, Jag, what is this Area Wireless program?
So Area Wireless is a new member initiative that we've launched, and what it allows our Realtor members to do is save a lot of money on their monthly phone bill, both for themselves and their immediate family. Now, the plan itself is $50 a month plus GST. It is a bring your own device. It's powered by the Rogers network. So we're talking about the largest wireless network in all of Canada. It includes unlimited calling in Canada, Canada-wide, and it also includes 3 gigabytes of shareable data. Now, what this basically means is that you're sharing 3 gigs per line.
Right.
So everybody on the contract gets at least 3 gigs allocated to them. What this means in practice is that we're offering virtually unlimited data as long as we don't breach our pool, which hasn't happened. We have some users using very little
You're talking
data.
like
Like
everybody.
500 people each have 3
3
gigabytes
gigs.
of data, and
You
those
got it.
500 have that giant pool of 3 times 500 to pull from.
You got it. Yeah. So we have
interesting.
some users
More
using
YouTube videos.
Interesting.
1 gig, and we have some users using 20 gigs.
Right.
Yeah.
As long as it all evens out in the end, we
Interesting.
haven't had one time so far where we've breached our pool.
Cool.
Interesting. So
Yeah.
how do they get more information? How do they sign up?
Go to our website, or you can call Simplex Mobility at 1-877-689-8289.
What we'll do is send out in the email we send out at the end of this some additional information on this. You guys are busy. I appreciate you guys
Yes,
taking the
thank
time.
you very much.
Thanks for
guys.
having
Thanks for
us.
having us,
Yeah.
guys. Yeah.
Absolutely.
It's really important for us to communicate with our members, and this is a great way. And it's
Thank
better than being on the road. We've done 12 different board visits,
Wow.
and it's been tiring.
Or you
so-
walk into brokerage and
bet.
there's
Yeah.
5 people in an office
Yeah.
meeting sitting around
Yeah.
the table.
Yeah.
So
But-
very important
yeah.
still, but
Yeah, well, absolutely.
absolutely.
Everything's important.
Thank you
Awesome.
very
Thanks,
much.
guys.
Thank you.
We're going to watch a quick Ninja video here, and then we're going to be back with a quick look at some checklists you can put in your business.